This is Lecture 1 for Class 6. In this lecture, we will be talking about updating and verifying statutes and how that can affect your legal research. One of the primary tools lawyers use for this task is Keysight, and we will be reviewing it in this lecture.
When we update a statute, we want to check its validity. The statute may be affected by proposed legislation that will change the text of a law, or adopted legislation that has not taken effect in the text of the code. Or its status may have been affected by a court decision. Remember, statutes, regulations, and cases are all dependent upon each other. For example, a court might decide that a provision of a statute is unconstitutional. We see some of this reflected in the Defense of Marriage Act, codified at 18 USC Section 1738C and displayed on your screen. In this example, Westlaw Next is telling us that there is legislation that was proposed, and also case law that affects the validity of the statutory code section. The yellow flags are meant to caution you about using the statute without investigating its validity further. If the statute had been repealed or overruled, the signals would be red and would signal you to stop from proceeding further. To explore this history of this treatment further, we will use a feature on Westlaw Next called Keysight. Keysight is used to update and validate the law. It can also further your case law research, which we will review in greater detail in class. The validity of a law is very important. A law might be repealed by the legislature that created it, or, as in this situation, the law may come under the scrutiny of the judiciary. Under the History tab, you can select Validity to review the language of the proposed revision, as well as the case law that has interpreted this code section. While proposed legislation does not change the text of the law until it is adopted, if you are tracking a statute or practice in a group that focuses in a particular area, you will want to stay informed about possible changes to the text of the laws that you work with, so that you can advise your clients for prospective behavior. Here, the legislation has not been adopted. It may be reintroduced in the next legislative session. I also mentioned that case law can affect the validity of a statute. Here we have a case from Ohio that has called the validity of the code section into question. It is important to note the jurisdiction of the court in order to decide if the decision is binding or persuasive. If we are in Hawaii in federal court, will this federal district court be binding on us? I'll let you figure that out. Let's go back to the main document by selecting it from the tab set here. I want to point out that the Westlaw Next editors will alert you to any additional treatment involving this law from the Supreme Court that has addressed its constitutionality. The Supreme Court decision would be binding on us here in Hawaii, so we need to pay attention. Within this note from Westlaw Next, the editors are telling us that this code section was part of a larger law, Public Law 104-199. You might remember that the 104 stands for the legislative session in which this law was adopted, and 199 is the chronological order of that law. Remember, we looked at slip laws a few weeks back. This is the first form of the published law as it exists before codification. This is what the law looked like before it was put into the U.S. Code. See that it is amending our code section in this paragraph. But It is also amending language in Title I of the United States Code. This is just a simple example of how one law is divided up into more appropriate topical arrangements that you find in the United States Code. We'll be reviewing the legislative history of laws later in the semester. If we go back to our initial document, we can link to the text of this Supreme Court case to determine how this case affects our interpretation and application of this statutory code section as it resides within the full text of the public law. You will have to make adjustments to your case law research and determine if cases decided after 2013 are relevant for your analysis. Keysight can help you do this too. You will have to make adjustments to your case law research and determine if cases decided after 2013 are relevant for your analysis. Keysight can help you do this too. Let's take a look at another provision of the United States Code, 18 Usc Section 1030. This is a criminal law section. You know that to be able to cite to a law on a database under correct Blue Book style, you need to visit the credits on Westlaw Next. An easy way to get there is to click on the currentness statement. That will take you to the bottom of the code section. Below the text and the credits of the code section, online or in print, you see the history of enactment and amendments of this one code section. If you count them up, there are 9 amendments to the original code section. These are seen most easily by identifying the public law number for each amending law. The first law in the list is the original law. In this case, we see that it was enacted in 1984. The very last entry is the most recent amendment, which took place in 2008. The amendment prior to that took place in 2002, and so on through the history of this statutory code section. If you are dealing with a criminal procedure that took place in 2007, the language as it appears now is different from the language that appeared in 2007. And any case law that was decided after that 2008 amendment may not be applicable, depending on the change in the law and how that was interpreted. For example, under the citing references, we see that there are more than 1,400 cases interpreting this section of the law. We can then use our filters to limit these results to cases that are binding on us in Honolulu. This would include the Supreme Court, the Ninth Circuit Court of Appeals, the District Court for Hawaii, and any state court decisions from Hawaii. There are no state court decisions here. We could also limit by date if we needed to make that adjustment to the case law settings. And you can see we have limited our cases down to 17. So it's very important to review the older language, not only for the text of the statute, but also for the text of the cases. So we need to determine what that language looked like in order to make our correct research decisions. If we go to the History tab for this document, we can access the older versions of the statute under the Versions tab. The editor's note will provide you with some short annotations about each change in the law over the years. But Westlaw Next also has a nice feature under its History tab that will help you identify the changes in the law and provide the text of the law as it existed in different time periods. So if we click on History and look at the graphical statute view, you'll see the nice timeline that Westlaw Next provides for you. This is an interactive timeline that has important documents for the legislative history attached to the appropriate year. This feature will be particularly useful when we start looking at legislative history. Under the interactive timeline, you also have a linear representation of the law. You can open up the plus signs to access the relevant documents. Since we were interested in the language of the law prior to the 2008 amendment, we would open up the 2002 version and click on the statute. This was the last version before the 2008 amendment. Notice in the upper right-hand corner of the screen, there's a note from Westlaw telling us that this document may be out of our subscription price plan. That would mean extra dollars for you if you were paying for this on a flat rate contract. As an alternative, I want to introduce you to the USGPO Federal Systems webpage. The GPO is the printing office for the federal government. We can access archived versions of the Federal Register as well as the U.S. Code and the Code of Federal Regulations. If we're looking for an older version and we have the citation, it's easiest to just click Retrieve by Citation. And from here, because we know we want to look at the United States Code, we can select that publication from the list. And here, we're given the opportunity to select the year that we want. The archive only goes back to 1994, but that's okay because we're looking for the 2007 version of that code section. Our title number is Title 18. We're going to select the main body of the U.S. Code. There is an appendix to the U.S. Code, but we're not interested in it right now. And from here, we would enter our section number, which is 1030, to retrieve our document. The issues at the state level are the same. We need to check the reliability of the statutory text to see if any legislation has been introduced or cases decided that affects its validity. When we get to the state level, we are not going to see as many conveniences as we see at the federal level. Let's use this statutory code section as an example. HRS 587A-4. This is the definition section for the Child Protective Act. Notice that Hawaii does not use the public law number in its credit statements. Here you see that the first time this law appeared in the Hawaii Revised Statutes was in 2010, and in Hawaii we give these laws chapter numbers rather than public law numbers. This law was most recently amended in 2013. If we come back up to the History tab and open it, we see that we do not have as many choices as we did for the federal laws. There is not a graphical timeline, nor are there different versions of the law. From this page, the best we can do is open the editor's and reviser's notes. Here you'll see the amendments are listed, but they are not hyperlinked. We would need to go and look for them, which is a subject of our Hawaii Legislative History class. This concludes Lecture 1 for Class 6. Please proceed to Lecture 2 for Class 6.